All right. Good morning, everybody. Looks like members of the public are starting to join, and let's just wait one more minute for Assemblymember Kamlager, and then we'll get started. Oh, there she is. Good morning, Assemblymember Kamlager. Can you hear us? Terrific. So the committee, the California Committee on the Revision of the Penal Code is back in session. Good morning, everyone. Senator Burton is not feeling well and won't be able to join us, but we have a quorum and we're going to get started. Thank you all, both committee members and members of the public, for what was a long, but I think hopefully helpful and informative session yesterday. Today we have 3 items on the agenda, what we're calling new business, which is the business that was just discussed yesterday. And the idea here is to prioritize a number of areas for further research and study by committee staff. Then ongoing business, which is really just a cleanup from our previous meeting, which is mostly ceremonial, so there's not much ongoing business to discuss, and then administrative matters. With that said, let me just jump right into the new business. Again, thank you all yesterday. Thanks again, especially to Tom and Brian, who pulled this off electronically and got all of our witnesses together, and everybody, was present. And I thought the presentations were excellent. I wanted to start today's conversation with somewhere the area that I sensed, at least, there was the most consensus. So rather than going in order, but to start with Judge Lowenthal's diversion pilot program that went on in Los Angeles, and talk about diversion for a little bit. I thought that his diversion program made a lot of sense. And I would personally like to see some more research into what exactly happened in LA, try to find out if there is recidivism data available, and to see if there's a way to develop that program as a statewide measure. I was wondering if other people had thoughts about Judge Lowenthal's idea. Dean Richardson?
I agree. And the only additional piece of data that I would like us to try to collect is the data on who participates in that program, broken down by race, gender identity, etc.
Yeah, there seemed to be a lot of consensus, obviously, on data, and I think everything that we do, we'll probably want to have some data component. Senator Skinner?
Yes, as Judge Lowenthal indicated, I'm very, very supportive of this program, and we tried to move it forward in the last year of the Brown administration. I'm not sure why we did not attempt again in the last year, but I think just as an FYI, my staff may be looking at trying to do something more immediately, only because of the benefit of reducing the number of court trials. And given that we're still in this COVID-19 circumstance, and we know there's a limitation on the ability to have court trials, it could be something that, at least as an interim measure in the COVID-19 circumstance, that could be acted on right away, while we also, as the review commission, look at it for a long term. But I think it's from the data that my staff and I had looked at from a couple of years ago, it was very effective. So, but the thing that I would really want to dig a little deeper on is the issue around post-plea or pre-plea. So just that note.
I agree. Yeah, Judge Espinoza?
That's all I was going to say was I worked with Daniel when we were in the same district, the Southeast District in the court, when that program was being launched and run. And I think it's critical that it be a pre-plea intervention, because otherwise there's too much that goes on in the courtroom to make it beneficial to more people. So that's my only. I mean, if we can get that through as a pre-plea program, I think it would be awesome. And to me, when I asked that he be invited as a speaker, to me, and I know we don't like to refer to things as low-hanging fruit, this is really low-hanging fruit. I don't know what it's like in the rest of the state, but in Los Angeles County, we don't hold misdemeanors in the county jail. So there's just no room for them unless they're suffer from serious mental disorder or they have a DV or a drunk driving case. But there will not be a lot of hand-wringing in Los Angeles County over a pre-plea diversion program for carved out misdemeanors. Thank you.
Carlos.
Yeah, I agree with everything that's been said, and I think the timing is propitious here, not only with the COVID-19 situation and how the law enforcement partners are dealing with that particular crisis, but I think as DA O'Malley said yesterday, there's been a real sea change, even in the last 2 years. From all accounts, the pilot program was very successful, and my initial thought was, hey, why hasn't this thing been implemented? But I think with new DAs potentially, a new DA in San Francisco and a race here in Los Angeles with one more progressive DA versus another DA, I think that the timing in terms of getting law enforcement support will be there. So I think this is something that has a really good chance of being passed with law enforcement's DA support.
Yes, Dean Richardson.
Two other things that were brought up yesterday with regard to diversion, and I should have started saying I agree with everything that's been said so far. Two additional things that I would love more information on because I thought they were great ideas that were mentioned yesterday. One was what effect would it have to create a presumption towards diversion or a presumption for diversion? That was brought up as a way of creating incentives. So within the code. And then another thing that I'd love to learn more about is how would we or should we mandate participation of county agencies? This was something that was brought up yesterday because we need their participation to do some of these diversion programs. And to me, that was also connected to section 1001.36, which was mentioned as being problematic because there's some inability to get resources for the mental health evaluations that need to occur for some of these diversion programs to work. So those are the two additional pieces of info I would love to see.
So I agree with that too. I have a question for you, Dean Richardson, or to the group. And you brought up, I think, two separate ideas. Let's talk about the presumption piece first. That seems to be that it could be eventually part of what we can call for now the Lowenthal idea that for at least certain crimes, it's presumptively goes towards diversion. Or did you see that as a completely independent mechanism?
I think it could go either way. So I'd be curious to see research on both and what the costs and benefits are of both.
Right.
Yes,
just very, very briefly. I mean, there is some precedent for that. I mean, it goes back to the Stone Ages when I was a judge in Compton on the municipal court. But I think in the standard penal code, there's a presumption that people should be released OR on misdemeanors with certain exceptions. I remember that argument being made to me. So it's not such a novel idea, but I think it's one that would be very apt for what we're talking about right now. The other point I want to make is that, again, going way back when I was on the municipal court, this whole thing about eligibility versus suitability. And I think in the Lowenthal plan, I think the court has virtually complete discretion, if I'm recalling correctly. But I remember being stymied by DAs who said the threshold question is eligibility. Second question is suitability for the judge. And it seems like under the Lowenthal plan, the really discretion rests with the judge on both issues. I mean, with some limitations. So I think to the extent that we can give more discretion to judges to make these decisions, I'm in favor of that as well.
I agree. I don't want to lose your point, Song, about the incentives, and we'll come back to it. But I think that that's the main feature of what we'll call for time being the Lowenthal plan, which is that every other program that we discussed yesterday, almost I think without exception, required the DA's acquiescence, all the collaborative courts, and the Lowenthal plan put that into the judge's hands, which I think seems to be something that I support, or at least preliminarily, it seems like a good idea. Yes, Assembly Kamlager.
So I too agree. It did make me think back to the panel section with Anthony Adams and the DA. And, you know, if you have a defendant that comes in with multiple charges, one of those charges might be diversion worthy, and then one may not. And then you will have a situation where a prosecutor is saying, let's take the totality of the sheet, which includes these non-diversion charges, and could use that as an opportunity to dissuade or prevent this opportunity from moving forward. I think upcharging does happen. So hopefully in our thought process, we can figure out what the appropriate guardrails are to prevent that, because what you don't want to see happen is a continuation of nons getting these opportunities without us really being able to take a deeper bite at the real apple.
I agree with that, and that raises the question about, you know, Judge Lowenthal's program was limited to misdemeanors, and then it was even, there were some misdemeanors that were even excluded. Do people have feelings about eligibility criteria? Dean Richardson?
I don't think we should limit it to, but I would love more research on this too. My initial feeling is we shouldn't limit it in any way. The impact of the last panel and the, I don't have her name in front of me. She had to leave the call early when we were talking about, yes, exactly, right? Like the points that, that she made about the impact of a program on her, and also the whole talk about restorative justice and leaving it open. Those lessons, I think we should take into the diversion area and really leave it open and have it be on a case-by-case basis, perhaps.
Senator Skinner?
Yes, I agree with what you described, Chair. And as I mentioned yesterday, was particularly struck by Ms. Dixon, who we didn't get to hear from as much as I think all of us would have hoped. Maybe we can have her return at some point and have a couple of other people who are in her circumstance to be able to hear from them. I think that while it is appropriate for us to focus, or just in general reform to be focused on low level and nonviolent, I also think that we err in completely ignoring, for lack of a better word, those that are categorized as violent, because there are so many things in the penal code that are in effect defined as a violent crime, but for which, you know, it's, I don't want to call it quite interpretive, but there's just such a wide range of what's considered violent. And I think that we should use, I don't know if I want to say risk assessment tools, because I think we have seen a lot of inadequacies in many of those. However, I think that there is good data on the types of individuals who pose greatest risk, and whether we have to improve risk assessment tools or turn to data or something. I think we just need to, and this I guess is in general for our penal code review, that we give a good look to all of these categories of violence, so that we are not just ignoring that in terms of our suggestions for revision and reform.
Judge Espinoza?
I want to agree with that. And if you factor in the issue of mental illness to a lot of these cases, I'm now talking individual cases, particularly in a charge like 422, right? Threats of violence. Many times when you factor in the issue of mental illness, the crime is just not as serious as it looks like it is on the charging sheet. It just isn't. And if you look at, and I don't want to spend a lot of time talking about LA County, but I have a tendency to do that. In Los Angeles County, we have a felony pretrial program for mentally ill inmates that we're pulling out of the jail. We have 2,000 right now in either interim or permanent supportive housing who would otherwise be in jail or prison. And the RAND Corporation did a study of outcomes on that housing program. We have a 71% housing retention rate, a 14% recidivism rate, defined as a new felony conviction. And my point is that the culture here in Los Angeles County has evolved, not only amongst the justice partners, the DA and the public defender, but the court. The court on its own expanded our felony pretrial program from one district to all 12, and of course sent us scurrying for resources. But we're catching up, and we're now diverting people in a 4,000 square mile radius in Los Angeles County. So it can be done. I don't want us to limit ourselves. I think we should be talking about, when we're talking about a presumption of diversion, we should be talking about felonies. I don't know how we characterize them, but we should be talking about felony. And I will say that, and I'm not a politician, I'm not an elected official, but I know that when we include DV and drunk driving cases, we're going to activate, or we're going to motivate the activist community, the victim activist community, to come out against the work that we're doing. That's the only cautionary statement I'll make about that. But I'm in favor of anything we can do to give judges more discretion to do the right thing. Carlos will agree that after years and years of trying to do the right thing, it's not always easy, right? Because of the lack of discretion. So thank you.
I will add one, I agree. And I will add one dynamic that didn't come up yesterday, especially when you're dealing with misdemeanor and low-level offenses that have short sentence exposure versus treatment programs that might go on longer, is that sometimes defendants have incentive to plead guilty and take a few days in county jail rather than participate in a 6-month treatment program. And if you only are eligible for very short, for crimes that are very short sentences, then it just makes sense to take the 10 days in jail rather than the 6-month treatment program. So if you don't expand it to crimes that have longer sentences, sometimes de-incentivizes or undermines the program. All right, well, there seems to be some consensus around trying to do some more research in this diversion program, obviously collecting data. I think everybody agreed about that. I think we need to think more about the pre-plea, post-plea issue. There is the presumption piece, how we could possibly expand into felonies. One piece that I didn't want to drop off, Dean Richardson, was your incentive idea. Was that different from the presumptions, or was there some other thought that you had there?
No, it was connected to the presumptions.
Okay. And Senator Skinner, obviously, we're very curious to see what you're able to pass in the emergency status that we're in, and we'll track that and see how that might be some sort of pilot or begin to have a runway for something a little bit more perhaps comprehensive. So
Michael, one of the things that came up from a couple of the judges in the first panel, and I know of Judge Espinosa's work here in LA, is that they were very small courts, and not all judges are versed in diversion programs in the courts. Not all judges believe in their ability to be successful. So I don't know how that is addressed, but I feel like we on this task force are operating with the same kind of vocabulary and understanding. But I wonder, and this is a question, if the entire bench, operates with that kind of uniformity. And my suspicion is that they don't, based on, either cases that I have looked at or stories that I have heard, or even some of the discussion that we had yesterday from the panelists. So I would hate for us to come up with something with a false assumption that the bench is, homogenous in its acceptance and belief in these programs.
I agree. And Mr. Adams said something that was very interesting to me, that we should follow up on data, which was that there was a mental health diversion statute that was passed last year, the year before, I think from Senator Bell's office, that, and he said once that got enacted, it attracted the defense bars like a laser beam on it, and that they were able to use that, even though, as my understanding is that much of the authority to do what was in that mental health statute already existed in law. It just wasn't specifically specified for mental health. And so, the question is, if we build it, will they come? And this gets to, I guess, the incentive issue that Dean Richardson was getting to. Before we leave the diversion piece of the panelist conversation, Tom, were there any other issues that came up yesterday that we just should not miss?
I think we've covered most of them. And on the diversion piece, I do want to add there are a few other states, including a state like Texas, that has a similar program. So I think, it makes a lot of sense for California to join those ranks. So those other states, I think, will be instructive for us. The only other idea I think worth flagging was from Mr. Adams, talking about the initial burden and making a request for mental health diversion, where he said, in the smaller counties that don't have as much infrastructure, have a contract public defender program, that it can be difficult to get the mental health evaluation that needs to be done to prove eligibility for the program. And he suggested that perhaps a defendant could make a prima facie showing and the court could order the evaluation and perhaps share some of that cost. That might be worth discussing. That's the only other thing to add at this point.
Just remember.
Dean Richardson?
And I just remembered one more thing I wanted to flag, potentially as a future hearing or testimony, and that's the LEAD program that started out of Seattle, the Law Enforcement Assisted Diversion program that Lisa Dugard and the Public Defender's Office working with the police started. And I think that is something that could also potentially, we could learn lessons from that might impact what we might want to suggest as penal code revisions.
I agree. Judge Espinoza?
I just want to offer our harm reduction specialist, Shoshana Scholar, who operates 3 lead sites in Los Angeles County, one in South Central or South LA. It's a partnership between the Sheriff's Department in Compton, Linwood, and the Long Beach Police Department. And it is remarkably successful. We received a grant from the BSCC to launch it. I would encourage you to invite her to speak. We have another pilot in Hollywood, and we're launching an opioid-focused lead program in East LA this year with money that we've received from the federal government. Getting money from the feds right now is a little complicated because it comes with a lot of conditions, but we were able to accept 2 grants, opioid-based, opioid-focused. But yeah, I would love for you to hear her talk about harm reduction, needle exchange, and the whole sort of panoply of efforts that are being done to reach a really vulnerable population. Thanks.
I see another hand up. Barbara?
Checklist of ideas relating to the penal code for diversion that were raised in either the discussions or in the binder. And I just wanted to double check that you weren't interested in pursuing some of these other ones that were in the, were mentioned. One was Judge Lowenthal in his written materials presented a possibility of amending Penal Code Section 1385 so that a judge can dismiss a case for rehabilitative purposes. And that was one idea that he had raised. He presented some draft language. I don't know if anybody pursued that in a bill at some point, but that was one idea that was also mentioned. Another one, DA O'Malley said something about recognizing the legitimacy of certified peer support specialists, but she didn't talk about that in her presentation. Then she also mentioned something about alternative ways to pay restitution. That came up in one of the other presentations as well. And then the last one was early flagging of inmates with mental health problems.
Thank you, Barbara. So, right, we discussed the idea of the dismissal. That was with the Lowenthal idea, and Tom mentioned the early identification of people with mental health problems in the jails. And so I guess the only thing that we haven't touched on, I was wondering if anybody had any comments on, was DA O'Malley's presentation and the programs that she seemed to be very supportive of, at least in Alameda County. And I think that, especially given her status as the president of the DA's Association, we should take those seriously. Anybody have any thoughts about those? Yes, Carlos.
Yeah, I think, my recollection is that was a kind of a pilot program, and I think she got funding from some source. This is the one involving formerly convicted individuals who were acting as mentors and peer counselors. I mean, it sounds like a great idea. I think she wanted Medi-Cal exemptions for them so they could continue to get Medi-Cal. I mean, I think it's worth looking at. And I mean, that's all I can say. It sounds like a good idea. On the 1385 issue, that statute has been in existence for as long as the Penal Code. And the judge's dismissal powers are very circumscribed. And I think the rehabilitative purposes is kind of vague. I could just see a lot of litigation coming out of that. It'd have to be more precise, but I think my initial response is that it's something that is probably a little bit too far out there. I know in the 3 strikes arena, back in the Romano case, back when I was on the court, judges use that to strike strikes. That would be a beginning to look at that to see what authority the court has. I mean, if we're talking about amending that statute, I think it has to be very carefully drawn so that as much as I think Peter and I like to give judges discretion, we don't want that discretion to be unfettered discretion. So I don't know how far that's going to go. I mean, 1385 is kind of like, it constrains judges from doing crazy things.
And I thought I agree, and I thought it was interesting that there's appellate review, right? So that would,
Oh yeah, there's plenty of cases on 1385.
Did other folks have ideas or thoughts on the O'Malley programs? Dean Richardson?
I thank you for raising all of them, and I found them all intriguing ideas, and so I would be supportive of following up and getting more information on those too as we proceed.
Assemblymember Kamlager?
Well, I think it's always strategically wise to find ways to create partnerships with the DA's Association, because oftentimes they carry the longest and most piercing spear when they come before us in public safety. I do think that her peer support specialist suggestion was also, for me, reminiscent of the recommendations that Sujatha shared. And so I think there's a spirit of restorative justice in those suggestions. So I'm intrigued by that one for sure. and would be curious if a DA O'Malley would be interested in trying to flesh it out even more so that there were some greater elements around, you know, who the peer support specialists can be. Because as we've seen through all of our experiences, one person on one side, you know, a specialist might not be the same as the names that would be on the other side. And so, you know, how to kind of mesh something together that's a little more symbiotic. But I'm intrigued by that for sure.
I agree. Senator Skinner.
Well, I want to first go back to Barbara Gaal's comments and want to say that I agree with her comments on the LEAD program. And now on the O'Malley programs, I agree with Assemblymember Kamlager's comments in generally around DA issues, but on the peer support program that DA O'Malley raised, it is funded private sector foundation. It is not funded either by the county or the state. And not saying, when I look at just given our revenue potential forecast for the next couple of years, probably, well, just generally probably hard to fund a lot of new programs. However, one of the things that we as the review commission could think about is whether over time in our final recommendations, what type of private and public partnerships we might suggest in effect for programs like this. And then on the restorative justice, I don't think she was able to describe that quite as much. I can't remember, but clearly I think there's a lot of data showing good value in appropriate restorative justice programs. So I think it is worthwhile for us to get a little more data on that, and especially when it comes to violent offenders.
Before we move on, does anybody else have anything to say about diversion programs? Okay, so to summarize, we will do further research into what we'll call the Lowenthal program, in particular its relationship to 1385, the data, pre-plea, presumptions. Also, we want further research into the LEAD program, what's going on throughout the state. That's a police and ground level law enforcement diversion program. And then circle back with DA O'Malley about programs that she thinks are particularly successful in Alameda or perhaps that other DAs are using, particularly thinking about the peer support programs and the restorative justice angle, and whether or not we can get public-private partnerships involved with that. Now, moving towards the collaborative courts session. My question for the group is, there seems to be widespread national support that collaborative courts are better outcomes, save money, are just great overall. However, there does not appear, and we've done research, I've had students look into this, Tom has looked into this, does not appear to have any real statutory authority throughout the country, to where the few areas where there has been some statutes around collaborative courts. There are a couple in California, but I think that Washington State maybe have the most comprehensive statute. New York State was mentioned. They're very, very advisory statutes. It's suggesting that if a jurisdiction wants to establish a collaborative courts, it can if it wants to, and if it does, it should, but does not have to include, X, Y, and Z. And I guess there's an empirical question that I have is, if you enact those kind of advisory statutes, does it make a difference? That's something that we can actually research and find out, if we build it, do they come? Or is there a way that we might be able to, and this would be really groundbreaking nationally, to incentivize it, to pick up on Dean Richardson's idea, or perhaps in some cases, even require it. And I was wondering if people had thoughts about how do we, maybe I'm assuming that we all think the collaborative courts in the abstract are a good idea, but how we might be able to expand that in California or encourage it. Carlos.
Yeah. This is just a preliminary thought. I think you point out, and I agree, there's kind of a tension between whether or not you do enact some kind of statutory provision for collaborative courts or restorative justice. It seems that in the lacuna or in the absence of any particular formulation in the statute, the courts have been very creative. And the tension I see is that maybe they like not having any statutory framework because it allows them to experiment, if you will, with different types of approaches towards achieving justice. So, because once you get it into a statutory framework, you have eligibility things and suitability and the whole framework. So I think we're kind of at a stage, and maybe it's been going on for decades, where we're letting local courts and counties, if you will, decide, what works in their particular jurisdiction. So I just, my sense in reading some of the articles and listening yesterday, it seems that maybe they don't want any kind of provisions, because then it sort of constrains them in their creative efforts. That's just my general observation, but I'm open to any kind of ideas.
Dean Richardson?
To pick up on Judge Moreno's comments, I did hear the desire to experiment and innovate. Yeah. I also heard the desire, though, to increase the number of courts and the incentives to engage in it. And two ideas that I would love to hear more about that I thought were great. One was potentially having the sentencing laws explicitly acknowledge collaborative courts, because that might increase the use of those courts. And second was to tie funding to, or to even give more funding to those courts that were willing to experiment with collaborative courts. So that was another idea that still leaves room for innovation and experimentation, right, but creates the incentives for more judges and more court personnel to experiment with those. Yeah. So those were the two that I thought were useful to get more information on.
Any other thoughts on this? I think this is a very tricky area because Carlos, I agree entirely that we don't want to stifle innovation. We heard from 3 judges who had active collaborative courts going, so of course they like what they're doing, and they're just going to say, let me do, continue what I'm doing. The question is, how do we expand those to other counties? I think funding is going to be tricky, Dean Richardson, right? As Senator Skinner mentioned. So I think one of the challenges that we're going to have is to try to find incentives that are not financial incentives, because, and Senator Skinner or Assembly Member Kamlager, this is, I guess, a question to you. It seems to me that the legislature does not account for long-term savings that a program like a collaborative court might generate for the system. That even though that they might have higher upfront costs, which I'm just going to presume that collaborative courts do, that the budget does not really recognize a savings that might be down the road. Is that correct? Yeah, Senator Skinner.
Well, it's, you could say legislature, or in fact, it's the general practice of the state and the Department of Finance to rarely factor that. And there have obviously, each of us, whenever we do a bill or whenever we advocate for a budget action, for example, me as chair of the Public Safety Budget Subcommittee, we always try to get the data that shows the cost savings, the avoided cost due to it, but it is not guaranteed to be factored in terms of the budget decision. So, yeah, that's just the real.
Thanks. Assemblymember Kamlager.
Well, it's also hard because our in the legislature, you know, the timelines that members have varies from, you know, a couple of years to a couple of more years. And so what will happen is you will have data that's shared that shows how this creates a long-term savings, but it also means you have to have an upfront investment. And the public likes to see very quick returns on investment. And it can be hard to marry the two in a way that makes sense. And oftentimes these are both budgetary concerns, but they do kind of bleed into philosophical tensions around what public safety and what criminal justice looks like. So you can be having two parallel fights and making the case in terms of a cost savings, but not, you know, still having the philosophical tensions rule the day. So that's sort of a challenge that we have to figure out how to maneuver in the legislature. But I do think it's worth kind of figuring out how to shrink portions of the system and kind of see the movement as levers. You know, if you're putting more money here, you're hopefully seeing a decrease in the number of cases and the number of people who are going into court and the number of rooms that are needing to be used. I mean, if you're able to say we've sort of decreased the kind of activity in this courtroom because now we're sort of partnering with these other groups and we're seeing an increase on the other side, you know, how do we figure out a way to support that? Because ultimately, I think our goal is to have fewer of these kinds of folks in the system.
I agree. Judge Espinoza?
I have more of a question than a comment, and I know that Los Angeles County and the City of Los Angeles have received funding through Prop 47 that was a realization of savings as a result of fewer people going to prison. I just don't know how those calculations are made. I don't know how that budget is created every year. I'd be interested in learning about that, even though my department has been the beneficiary of some of those dollars. I don't know how the calculations are done. I don't know. And I'd be interested, I think it would benefit us to learn about how that is done.
Assemblymember Kamlager or Senator Skinner, do you know how that's done for Prop 47? I know a little bit about it, but you may know more.
I know that what's the word? That there's many people feel it's calculated too generously, and other people feel it's calculated inadequately. So it's one of those circumstances that's because it's trying to project versus looking at what, you know, past, like actuarial so it's some people feel like for example, if you look at last year's budget, we showed in effect a savings or a revenue due to the program, and it was modest. Again, whether appropriately or not, but so it's it is a, what is the word? No, I don't want to call it inaccurate science. I want to call it
inexact.
Yes, exactly. Okay.
The way that I believe that Prop 47 is drafted is that it directs the Department of Finance or some other, and you could, you know, point the Judicial Council to estimate the cost savings. and then that number is used and then divided up according to a formula that's within Prop 47. So the statute directs some third-party arbitrator, whether it's Department of Finance or Judicial Council, to make that estimate of savings.
Right.
And then that creates the fund that I believe that's the way it's distributed. We could definitely look into that. Senator Skinner?
So Chair, I should have, your response and answer is actually much better than mine, because the benefit of it, while it may be inexact, the benefit of it is there is a formula, and thus we are using it. Compared to, for example, other changes that we make, say the bill that I authored that revised the felony murder rule. There have obviously been some number of people that are no longer in state incarceration, and yet, however, it could not, when it passed, it was not assigned a specific cost savings based on the estimate of how many people would actually potentially be released from a state facility. So the benefit of the Prop 47 formula is at least there is a formula that is used. So I think in that respect, our process recommending use of such formulas is would be a good thing.
Aside from financial incentives, are there other ways that and this is something that we can research, do people think that there are incentives that we can develop to create collaborative courts? Or do we think that merely providing the good guidelines, that in and of itself will create the expansion of courts that we seem to want? Senator Skinner?
One thing we might want to look at to get data on is the presence of collaborative and diversionary courts. So just where and how extensive. And then perhaps the data on the, what is the, just data on charging throughout the state. So we can see if there is correlation, perhaps a per capita or not, of where there may be significant numbers or whatever, more presence of collaborative and diversionary courts. And I don't know what indicators we might want to use, but either number of people being sent to state facilities or some other, we could come up with a variety of data points that we might want to look at, because that might help us see whether there is that cost savings correlation.
I agree. Senator Carlos?
You're on mute. You're on mute. Yeah.
I have a bunch of construction going on outside.
All
I agree. And I was trying to find somewhere in the materials, or someone said that there were 400 courts using, whether it was diversion or collaborative courts. I think it's probably diversion. But I think, yeah, some kind of data gathering on whether or not this is something that's fairly widespread and there's kind of an acceptance by the courts of these kinds of programs. So I agree with the senator.
Tom, you had a comment?
You have to unmute yourself, Tom.
Yeah.
Yeah, Judge Moreno, I was just going to say that 400 number, that was the Judicial Council's count of collaborative courts. So
That's a good number.
yes, and they break it down on each type of court in each county. I think every county but 2 has some number of them at this point.
Yeah.
The diversion program, that's a great question. I was not able to find any count like that, because that's going to be sort of each DA's office is going to have that, and perhaps we could get some help with that from the DA's Association, because I imagine they might want to be interested in that as well.
Yeah.
Brian?
Yeah, I was thinking it would make sense to talk to Judicial Council about all of this, especially if the approach is to create incentives rather than regulating how this is done. They may have ideas about what would help them internally to support courts that are doing this, or sort of foster cross-pollination across county lines.
Yeah, I think that we should go back to Judicial Council, definitely. I will say, aside, in addition to Prop 47, or similar to Prop 47, the funding program that was built into that statute is SB 678, which was for in probation. And with that statute, and I know that there's some controversy about that particular bill and how it worked, but at least in theory, the way that it worked was that if probation departments reduced the number of people that they were sending back to state prison for probation violations, that they would then get some portion, and again, as a formula, of the state savings to enhance their programs. So I don't know if 678 is kind of how that's thought about in the Capitol, and I'll defer to the lawmakers here, but you could imagine some formula where we could track collaborative courts, see if there are cost savings particular to the state, and then return those savings or portion to the savings in terms of reduced incarceration along 678 models. I don't know if anybody had thoughts on that, but there are different sort of cost neutral or even maybe cost keep us in the black, even in the short term, keeping in mind the Department of Finance scoring that Senator Skinner mentioned. Okay, before moving on, Tom, is there anything else from collaborative courts that we missed?
You know, Judge Manley had a few ideas, and I think the one that might be most relevant for this discussion is he talked about some of the classes or programs that are mandated in the penal code for some of the diversion. And he mentioned it yesterday when I spoke with him previously, that some of them just don't make sense for someone to have to go to a class every other week. It might just is arbitrary to have to do that for a year, or there's some classes aren't available any language but English, and so doing them making someone go to a class they don't understand what's happening, and he expressed some frustration with that. So I think it's surprising that you would have to go to a non-English class if you don't speak English, but he reports that it's happening. That seems like something we should look into perhaps as well.
I agree. And how it can be used against you, right? He said it can be used against you if you miss a meeting, and and you end up with these like ticky-tack violations that impede your ability to kind of get through. And I don't think it sounded like he said judges shouldn't really be a warehouse for, like checking off all of this work, or clearinghouse rather. So, and they conflict, he said, oftentimes. And so I was also very intrigued with how we can sort of eliminate some of that.
And I think one approach for it is what Judges Moreno and Espinoza were speaking about, is give judges the discretion to do the right thing, where don't require them to mandate a certain program if it doesn't make sense based on the particular case, and that seems appropriate. He also had mentioned the issue, Judge Manley had mentioned issues with bench warrants for people with mental health issues. And I think that's not perhaps directly a collaborative courts issue, but I suspect that people being afraid to go to court if they have an open warrant would, decrease people's willingness to do some of these programs. And it also, whether it's directly related to the topic, just seems something appropriate for the committee to consider, whether there should be alternative mechanisms for these sort of very arbitrary and scary bench warrants that can be out there for folks.
I agree that Judge Manley threw out at the beginning of his talk a handful of very specific provisions that he said were impeding his work, and we should circle back with him and figure out what those are. I think that it's, so far we've been talking about new laws, but as opposed to eliminating impediments, which could be quite helpful. Before moving on, does anybody have any other additional thoughts about collaborative courts? Okay, just to sum up, and then I think we'll take about a 5-minute break because we've been going for about an hour, and so let's take a 5-minute break. But just to sum up on collaborative courts, we talked about ideas that would maybe perhaps sentencing laws could somehow mention or incorporate collaborative courts, thinking about creative funding possibilities to further incentivize collaborative courts, whether that's a Prop 47 model or a 678 model. Certainly, I think we all agree to gather more data on what collaborative courts exist, I guess, in California, but elsewhere. One thing that we didn't talk about was that there's so many different collaborative courts. There's drug courts and mental health courts and veterans courts and caregiver courts, and maybe perhaps even trying to find data on which one of those seem to be most successful and where we might have the best opportunity, but certainly go back to Judicial Council and try to get data from them. And then to circle back with Judge Manley about the particular provisions that he thought were frustrating some of the things that he's been doing. Unless anybody else has any other comments on collaborative courts, I'd like to adjourn for 5 minutes and come back at 10:05.
Great.
All right, we'll come back at 10:05. Thanks. Let's give Assemblymember Kamlager and Senator Skinner a second. Oh, and we lost. Oh, no, there you are. All right, I'd like to move on to what was the, I guess, final panel on restorative justice and probation. Admittedly, those were two pretty divergent fields, and maybe we didn't get enough of each. But let's start with restorative justice. I thought Sujatha was really powerful. But of course, perhaps her top recommendation is, again, let's do no harm. Which, I think is pretty remarkable that she maybe is the nation's expert on this and is asking for no statutory support. So I was wondering how people thought about her presentation, restorative justice in general, and if there's anything that the committee can or should try to explore in this area. Dean Richardson.
So I take what she says about do no harm very seriously. She is the expert. The one thing, though, that might fall in the category of doing no harm but helping was confidentiality. And she mentioned that quite a bit. So I don't know what it is that we could or should do in that area to strengthen the confidentiality of the discussions that would take place during these restorative justice sessions or circles. So I just mentioned that because that was a topic of conversation and something she talked about in her written materials too.
I agree. One model that I think actually Kentucky uses, not necessarily for restorative justice, but for diversion programs in general, is that, and this is some of my students found this, was that if courts wanted to, if a specific jurisdiction wanted to implement some diversion program, or it could be a restorative justice program, that they would submit the proposal to the Supreme Court of the state that would have to sort of sign off on it. And you can imagine a situation where a jurisdiction says, we want to start a restorative justice program. Here's our proposal. It gets us, but it's approved by the Chief Justice or the Supreme Court. And then once you have that program in place, perhaps that could include a confidentiality provision that once approved by the Supreme Court, if you have a certified restorative justice program, that it could have the elements perhaps that Sujatha or others think are great, but I think confidentiality could be one of them. But it might be a mechanism instead of just, guaranteeing confidentiality in some broad, vague sense, but it might give some framework there. Do other people have thoughts? Okay, I mean, I think restorative justice shows a lot of promise. It's still new, but it's very complicated. Senator Skinner?
I did not ask Sujatha any questions, and I really appreciate her description of the, statutory involvement may not benefit. However, concern is if there is a feeling and there is data that shows that it is quite effective, then it's hard to get to get wide use of programs unless there is some type of whether statutory or funding type of support. So I think we need to explore that a little further, because I'm not sure. I mean, if we just look at the uptake so far, it's pretty minimal uptake, and I have a hard time imagining that it would become a larger uptake without some kind of signals.
This is I agree. This is a recurring theme, of course. It's like, how do we incentivize the programs that we want? Funding is the obvious answer, but given how it's constrained that might be, I think we're going to have to think creatively about that. Assemblymember Kamlager?
Well, I think we should sort of use COVID as a strategic testing ground for some of that. If we can get data on recidivism rates during this time, if we can, what the data will show about the maybe increased the level of pragmatism coming out of the courts in terms of charging, in terms of detainees, in terms of the kinds of deals that are made, and the levels of dismissals. I mean, so I think there's fertile ground here. And in my mind, that's as much an incentive as more funding. How do you recreate a system that's more efficient, that allows you time, space, and resources to focus on, the true folks that, should be coming through the system. I get that Sujatha said that they don't have a lot of data, but the other, I think, reality with restorative justice is that you're probably having different groups looking at different kinds of data that would be of interest to courts and prosecutors and public defenders might be slightly different than the data that community members and parents and victims and, grandmothers are looking at. And so there probably is going to be a disconnect in terms of success, because the data the community data that's relevant for folks, A, is not something that they're tracking, but B, it may be harder to quantify. But I think that's part of the underlying, some of the underlying elements and importance of restorative justice. It's sort of putting this back into the hands of community so that community can come up with the right punishment, for lack of a better word, or response. And that I don't know we should be putting in statute. It's also, once again, like the collaborative courts, it's allowing the creativity to come from community that knows best or has a better idea of how to regulate.
I agree. And I think that's something that we should try to think creatively about, and something that Sujatha obviously is at the forefront of, but also as Californians for Safety and Justice and the group called Victims speaks is that we've had these ideas of victim impact statements as almost always being more incarceral, but that can we develop programs, perhaps they're not true restorative justice programs, that address victims' needs and desires to make them whole in a way that is not just further punishment. I think that that can be explored. One thing that Tom actually uncovered was a statute from, when was it, Tom?
Well, the most recent version is from 1872, but it dates the one from 1813. So,
and it's
That's
still on
when
the
Penal
books.
Code was written.
Right.
1972.
It's still on the books. It was last modified in the 90s, actually, by Senator Burton, I believe. So,
So this is a statute that allows it allows courts to go to victims and say, have you been satisfied? You know, this guy broke your car window and it paid you back for are you satisfied? And if the victim says, yes, I am satisfied, then the court had authority to dismiss the charges. Right. So civil compromise. But in any way, is there a way that we can bring victims into obviously they're critical piece to the justice system, I think. And they've traditionally, or at least in the past generation, been thought of as been this incredibly powerful group for just to further punishments and increase incarceration. But I think what Sujatha is proving is that maybe just a portion of the victims' rights community, or I mean, I'm a crime victim. So how can we marshal what people truly want out of the justice system, at least from the victim's perspective? Carlos?
Oh, no, I was just thinking that on the civil compromise, I mean, again, when I was on the court, it's Penal Code Section 1378, basically involving business disputes and theft and things like that. I mean, I think it bears further study. I think it works to get the community involved. You know, when I just remember that when I was a judge in Compton, the city of Carson was in our jurisdiction. There was a large Samoan community there. So I can recall at least half a dozen instances where community elders came into the court to say, Your Honor, we are going to handle this young man. I always wondered what we're going to do to him. He says, whatever you're thinking of doing, you know, we'll straighten this thing out. I suppose that's a form of restorative justice, or the community having its hands in resolving some of these men. And I would dismiss the case, or put it over for a progress report and then dismiss it based on their assertions to me that the matter had been compromised or restorative justice had been applied. So I think it can occur in a variety of instances. The only thing that disturbed me about it was, I asked one of the questions about, doesn't society at large have an interest? I'm sure that'll be the DA's position. Secondly, in terms of, I don't think all cases are amenable to restorative justice. I think a lot of victims, particularly in a sexual assault kind of context, are not going to want ever to be in the same room as the assaulter. And you know, you see things about victims just being totally outraged, and the last thing they want is any kind of restoration of the situation. So it's complicated, and I'm just not sure how much of a buy-in there would be by victims and DAs and even the court. Those are my thoughts. I've seen it work, but I don't know whether there'd be widespread acceptance of it in different types of cases.
Judge Espinoza, do you have experience here?
I mean, I had experiences similar to Carlos's in terms of, I will tell you that I have presided over dozens of victim impact statements, almost always in cases involving sexual crimes or crimes of violence, usually homicides. I would agree with Carlos's assessment. It was interesting to hear yesterday's testimony in light of my own experience, but there's rarely a request to get to know the perpetrator and understand the reasons why the crime was committed. Generally, the request was for, as Carlos has indicated, increased punishment. So I think it's worth exploring. I'd like to, I will say that the Alternatives to Incarceration work group in Los Angeles spent an entire day on restorative justice and its impact on survivors, crime survivors, and it was fascinating. I mean, they did a circle with homicide survivors and former lifers. It was fascinating. I'm not sure about practical application based on the dozens again of victim impact statements I had to endure. I shouldn't say had to endure, that I sat through, because they were usually very tense, very emotional, and there was a lot of grief and anger mixed in. So, but I think it's worth exploring. I'd love to learn more about what that really looks like in the context of serious crime, which she said, by the way, is the kind of crime most receptive, most effective with restorative justice techniques.
Yeah. I guess the one other concern I have is I guess it's the societal interest. Is when I asked, you don't really see any involvement. They want to resolve these things outside of the court system. And I just don't see how that can be possible. Maybe I'm too narrow-minded on that. But if a crime has been committed, I think society has an interest, and the judicial process should be implicated. But she mentioned that they don't want the courts involved. They don't get any government funding. Just leave things alone. And maybe for certain types of offenses that works. But I think you really have to have the buy-in of the prosecution and even the police to step back and let things work out. In a family contact, maybe like, these city attorney hearings that used to pre-filing, I mean, that worked. I mean, city attorneys have wide discretion in terms of bringing charges in the first instance and resolving things informally. So that's another form of restorative justice. But that's also within the system, in a sense, at least within the government. So I think we should look at it more closely.
Assemblymember Kamlager, did you have any thoughts on this?
I did. I was actually very intrigued by her thoughts around plea conferencing and figuring out a way to, decrease court traffic. So I think in reality, right, these things happen all the time informally.
Yeah.
You come and you bust in my house, and chances are I know who you are. I can connect the dots and figure out, what happened. And I would much rather, without involving the courts, figure out a way to, get an apology or to seek some redemption so that I can move forward. Because the reality is, I don't necessarily want to call 911 and have this person be charged and have them, and then subsequently me, have to endure this process, this journey that I know is probably not going to end well. Chances are the person has had a run-in or has been stopped, and so that person's name is on file someplace, and I know that. So if I call the police and they get involved, then all of this extra baggage is going to bubble up. And then we've created something much bigger than the fact that you came in and ran up on me, because of my boyfriend or whatever the situation is. So I think we have to be honest about the fact that communities have been trying to figure out ways to informally, bring about compromise and closure, because none of these folks trust any of the people that are part of the system. They don't trust law enforcement. They don't trust probation. They don't trust the judges. They don't trust the DAs. They don't even trust the public defenders. So I think we have to be honest about that. And I think we also have to be honest about the reality that oftentimes court is this kind of contentious theater. You know, it's a battle, and people are invested in the continuation of this theater. And what I got from her is, how do we sort of diffuse some of that and find resolution in some other way? You know, people, the victims know who the perpetrators are. And so there is space to bring in the elders, to Judge Moreno's point, and family members and friends and even adversaries to say, is this what you really want? Do I want this person locked up? Do I want this person to potentially get a third strike? No. You know, I just want my shit back. And I don't want you to come back into my house. So and punishment is very different from the finished product. And we're always talking about the punishment. But the finished product is what communities want. You know, they want the person just not doing what they did. And so maybe there is a way to flesh out 1377. Maybe there is a way to expand it. Maybe there is an opportunity to figure out how to have it touch upon some of the kinds of charges that come up more often than not, where this could be appropriate. You know, I don't know that you would just sort of brushstroke it across the entire system. But one of the things I was looking at doing this year, which I guess I'm still going to do, is about community policing, which is an extension of this. It's you know, how the first responders don't always have to be the folks that people trust the least.
Dean Richardson?
I agree with everything that was just said by Assemblymember Kamlager. And I guess I would just reiterate that, at least where I'm coming from, not limiting restorative justice at all is, I was very persuaded by Sujatha and her plea that we not do that. And the reason I'm so supportive of that is, once you bring in the apparatus and the machinery of the state, everything just becomes more complicated, more expensive, and less innovative. There are so many ways, whether it's the most serious crime or the least serious crime, having a legitimate and appropriate mechanism for resolving these things that don't involve the current machinery of the state, I think is incredibly important, especially with what Assemblymember Kamlager just said, right? These things occur anyway, and often people call the police because they feel like that is the only thing and only option available to them, and often they regret doing that because of all of the consequences that they didn't realize were gonna come from this, and the way that both victims really regret involving the machinery of the state, even in sexual assault cases, domestic violence cases, right? Those cases that are typically taken out of any sort of diversionary type of program we might consider. So I would just love to get more information about, from Sujatha, about some of the serious cases that have been resolved appropriately through restorative justice, and would just really not want to limit the scope of that program and the experimentation that can take place by putting these, what I might call arbitrary requirements on it when it is so new and there is so much ability to try to experiment and innovate.
But the judges make a good point. Buy-in is going to be key from the bench and from the DAs. And part of buy-in is about getting on the same page around purpose. You know, that's why I'm always sort of thinking about, have we synchronized what our goals are, what our outcomes are? Because the bench, you know, we want to feel relevant, and we're doing a job that is important. And so how do we look at trimming the fat so that the true purpose is able to shine and be enhanced, and, you know, and why we have the bench and why they're there and the importance of their work and their role. and then the real role of DAs. I mean, if we can begin to sort of chip away to get back to that, you know, I think that is what people want when you're talking about a holistic, you know, criminal justice system.
Carlos?
Yeah, just two things. I agree with everything that has been said, and by no means am I against, you know, studying the issue further, but just a couple of anecdotes and then a position. I mean, I happen to grow up in Los Angeles in Elysian Park by Dodger Stadium, and even in a very closely connected neighborhood where everybody knew each other. So even in my own family, where there were two burglaries, you just talk to someone and say, you know, we know who did it or who did it, get that stuff back here, and the stuff gets back the next day. So in certain close neighborhoods that works. I don't know if that's a situation in other neighborhoods, but it happened to be the case, you know, where I grew up. Second, you know, my recollection is that the LA City Attorney's Office, not only do they have neighborhood prosecutors that are in touch with, you know, local communities, but I thought that at one point there were some kind of restorative processes in dealing with the kinds of crimes we're talking about. I think mostly thefts and loitering and things like that. So I think we should try to determine whether or not in a place like Los Angeles, something like that is already happening with some kind of government involvement, minimal government involvement, so they have their ears and eyes out. They know the community and they're able to resolve things informally without taking matters to the police or to the courts. You know, I did mention the city attorney hearing process, and that basically involves, you know, pre-charging resolution of cases. And back in the day, I mean, we had a number of hearing officers who would deal with these disputes, and then probably 90% of the time there'd be no filing at all. So I think that would be worth exploring as a kind of as a corollary to restorative justice. So both of those things. Do we have something already going on in some of our neighborhoods? And second, to what degree are these city attorney type hearings functioning in the same way?
Judge Espinoza?
I just wanted to let Carlos know that, in fact, the LA City Attorney's Office has a very robust restorative justice program, and it's actually managed by a friend of ours, Carlos, Camilo Cruz, Richard's son. Yeah.
Richard's son, yeah.
Richard's son. So they came and presented to the Alternatives to Incarceration work group on their program, and it's very impressive. Albeit it deals exclusively with misdemeanors, it's robust and it's logical and effective. So I'm sure they'd be happy to come and explain what it is that they do.
Can you give just a quick summary, Peter?
They engage, boy, I wish I could. They engage with a large group of community volunteers that work on the restorative justice piece, bringing both the alleged perpetrator and the victims of the crime together to talk about solutions and what it would mean to restore the victim to where they were before the crime was committed. But I'm not a subject matter expert, really. But it's a very, very, again, robust restorative justice program run by Mike Fear's office.
We can reach out to them. Dean Richardson?
I just don't want to lose sight of, and so I would like more information about the issues of power and privilege too that might impact restorative justice programs. So I think on the one hand, I'm saying I don't want any limits. I want people to be able to experiment, but I also want to be cognizant of the fact that there must be some safeguards, right? Because you could imagine a restorative justice program where, depending on where people are situated with regard to power and privilege, and I thought about this when Carlos was talking about the elders coming in. Right? So on the one hand, you can imagine that that's a very positive thing because we can take it to the community. On the other hand, the outsiders don't necessarily know what dangers might attend to leaving everything in the hands of the community either. So I do think
Yeah.
I'd like to hear more about the ways that there are some protections and safeguards in place with these programs.
Assemblymember Kamlager.
Well, that's why during the her presentation, I had sort of mentioned the involvement of counsel, because oftentimes people do know, you know, their clients' limitations, and I think people will be honest without divulging any kind of privilege. And so we should have, there should be, in anything, right, there should be some sort of guardrails in place to steer a process through. And there also should be, you know, safeguards, because like anything, you can, you know, something like this could be abused, which is not what you want. And left to our own devices, you know, community can get kind of mired in a whole bunch of other things. So I agree with Dean Richardson.
I agree. This is getting the thick wicket here. Before moving on to probation, we haven't heard from Senator Skinner on this. I was wondering if you had any thoughts, Senator Skinner.
Well, I just looked up. So other than Sujata's description of a restorative justice program around that involves violent offenders, and her recommendation that we, you know, that there not be statutory or other involvement, most of the programs that everybody's describing are around misdemeanors. Now, which great, I support, no issue. But when I look at the statistics of who is in our state facilities, at least by CDCR's own, the stats I'm able to get, 76%, in other words, a very large number are there for quote unquote violent offenses. And a lot of them are sexual in nature, you know, some murder, manslaughter, robbery. So I think that we, given that we're trying to look at the penal code with, you know, what works, what doesn't work, and I think that, well, just we have to dig down into more of these violent crimes, and we have to dig down into more of the whether it's restorative justice or what other practical tools might be available to us as within courts, within law enforcement, within the society in general, to deal with this potentially other than incarceration. And I think obviously Assemblymember Kamlager Dove, Judge Moreno, others have talked about, you know, we already know that in some of the communities most impacted by, or at least what data we would indicate are most impacted by some of these types of crimes, they do take it into their own hands because they don't trust either law enforcement or courts and such. So anyway, I just bring it up that it is an area that we're going to have to, and I'm sure we intend to, but go into really deeper if we want to really affect this whole issue of the penal code and the result of our current practices.
I agree, and I want to say a few things before wrapping up this and then moving on to probation. So I was actually recently, or my wife was recently, a crime victim, and her small business was broken into and lost a bunch of computers and stuff. And I certainly felt that tension that we've been talking about do I report this? We would report it for insurance purposes primarily, and what happened to these people, and will they ever be caught, and all that. You know, I was just personally conflicted there. So this is not even just within my community, or I mean, I guess in some ways, yes, but you know, I definitely felt that push and pull, and so I relate to that entirely. I still think that this is a very tricky area to get into. I appreciate what Carlos has been pushing in that the system and the state has a voice, perhaps independent from the particular victim in a specific crime. In part, that's to protect some of the interests that I think that Song was mentioning, that we don't want to privilege people who might have authority within their different communities in order to extract cooperation from victims. And so I think this needs to be done very delicately. But I do think that there are some areas that we can continue to research which are that, first of all, the confidentiality piece, we mentioned that early on, that should we develop or recommend some sort of restorative justice program, that needs to be a central part. I think that this question about, I'd like more research on victim impact and victim statements. They've, it's always been seen as a one-way ratchet, but is that really true? Sujatha, I think, is indicating perhaps it's not true. The funding piece, that, we've dealt with that all day. The one good thing about restorative justice, I think, is that it's a particularly hot topic, I think, among funders, and it might be a public-private partnership opportunities in this particular area. So I think that we might have some real opportunities there. Assembly member Kamlager talked about our sort of experience from the COVID situation, and can we learn, I think, not just for restorative justice, but just can these sort of collaborative type resolutions end up being more efficient uses of our justice system and end up with better or the same or even not better results. But the one sort of statute that we talked the most about, and perhaps we could dig deep into, is the civil compromise statute, and is there a way to expand that or think about that a little bit deeper? So those are the items that we discussed, and I think makes sense to think more about. Before moving on, Tom, was there anything from the restorative justice area that we should touch on?
Well, Nicole Kirkcaldy from Yolo County, she had mentioned two things about restitution and expungement issues. I think expungement, or I don't even know if that's the right word, honestly, which is probably part of the problem. I think that's a bigger issue for the committee, even outside of this context. So I think that's something that should be on our radar. And, I think the restitution issue is very tricky because, that is extending, to use, Dean Richardson's formulation, the machinery of the state into the restorative justice process if you're creating a civil judgment for money. And it also may, it's just discriminatory too for people who may not have funds no matter how long you give them to pay it. But those were two other ideas that came up yesterday in this context.
Something with Kamlager.
So she also mentioned, to kind of look through the lens of pre-booking. And so not wanting to have that lost. And then maybe a way for us to think about things as also, the use of technology. And I'm sure now during COVID, we've had an increased use of it. And so maybe there's a way for that to kind of, or long-term recommendations that come out of that, as a way to kind of spark some inventiveness about how systems are redeveloped and maybe find some incentives through that.
I think that makes sense, and I'm going to use that as a segue to move to the probation conversation, which was cut unfortunately short, but I think we'll pick up with when we talk about short sentences at our next full meeting. And I think probation uses technology a lot, and particularly the most obvious use is the electronic ankle monitoring and things like that, which we really didn't talk very much about. I do know that there are a couple of proposals in the governor's, at least, budget pre-COVID about probation that I think that we should keep our eye on, especially with a brand new budget that I expect is either out or coming out soon. Perhaps Senator Skinner could talk about. Those proposals were, I believe, to create a more specific pathway to get off of probation. I know Chief Keene described that there is a pathway, but that seemed discretionary, but perhaps that there's a statutory pathway to get off probation more quickly. I think that's in the governor's proposal, and also to limit probation to 2 years as I think both a cost-saving measure, but also just as an empirical realization that supervision past 2 years has limited benefit. The other issue that we touched on briefly, but I think Chief Keene agreed with, and this is, again, a recurring theme for today, is should there be limits on what crimes are eligible for probation, right? We have the judge as being the gatekeeper as to who goes on to probation, but right now there are statutory exclusions that say certain crimes are just statutorily not eligible for probation. Now, those are probably the more serious crimes. We don't need to say that they're automatic probations. There can be all sorts of presumptions, but I was wondering if people had thoughts on any of the above. I guess I'll start with Senator Skinner, if you're aware of any of the governor's proposals with regard to probation and the budget and how things stand there.
We have not, obviously, because of the COVID shelter in place, we've not been having the budget hearings yet, so we have not done our detailed analysis of those proposals, and especially given that we don't know what's going to change in the May revise. But I was very happy to see them, and I think that it is something that we really do have to look at. If you recall, in yesterday's testimony, we heard that there are over 355,000, I believe, adults under probation supervision, and we know that just depending on the circumstances, that can create a circumstance where you're limited in terms of not being able to leave your county. And with jobs scarcities, that may further impede your ability to get employment, which is already very difficult if you are a person with a record. And then additionally, there are rules now of where we release someone. So in other words, it's often where the crime was committed versus their county of residence. So they're then released in that area and forced to stay in that area under their probationary terms, where they may not have support and other things. So there's a lot I think we need to look at in terms of probation and in terms of its real effectiveness in our public safety goals. Because if it's really impacting people's ability to successfully function again in the community, then that's something we have to evaluate.
I agree. I just want to separate two separate items that you mentioned. First, there's the sort of sentence to probation. So as an alternative to incarceration, you go on probation, you're supervised, and those may have limits and constraints that get in the way. We obviously want to incentivize the best rehabilitative aspects of that. A separate responsibility of probation departments is post-release community supervision after you served a term of incarceration. I'd like to try to table that for when we talk about reentry issues. I realize that they're handled by the same department, but for the time being, I'd like to try to focus on the sort of alternative to incarceration part of probation, which means alternative to being behind bars. Mm-hmm. And one thing that I'm particularly interested in, and this is data, I should also say about data, is that the committee staff, Brian and Tom and I in particular, have been working very hard on getting as much data as possible from the relevant agencies. But this is one thing that I'd be very curious about, is who gets probation versus who gets incarcerated for the same exact crimes, which counties use probation extensively, which counties don't. Probation obviously was impacted greatly by 678, which I mentioned earlier. I know probation officers really love 678 because it brings a lot of money into them and reduces the number of violations. I do know that there's some, consternation perhaps in the Capitol about 678, and it's the impact of realignment. We can talk about that in another day, but that's a funding mechanism. So anyway, those are some of my thoughts before. Dean Richardson, you had your hand up.
This is in the area of more research about probation, because there's some argument that probation itself and community supervision in and of itself is criminogenic. As you just think about, if any of us even on this call right now were monitored 24/7, we wouldn't be able to manage being on probation ourselves. So I'd love to hear more about what aspects of probation and monitoring are criminogenic. How should we think about it? What types of, and in terms of data, I would love to know how often are probation violations based on technical violations, right? Being late to a meeting because your bus broke down, and having that be a violation that can result in further incarceration. So any research that we can get on the impact of monitoring while on probation, because we often think of probation as great because you're not in custody, you're not in jail, but the other side of probation with the incredible monitoring of every single aspect of your lives is not necessarily an unadulterated good either. So just hearing more about that, I think, would be useful.
Judge Espinoza, do you have any thoughts here?
I don't know what I can add to the conversation. I happen to think that SB 678 is by and large a positive funding stream. It's being used in Los Angeles County for lots of recidivism reduction services that are being provided by community-based organizations, not by the probation department, because the probation department historically has not, that's just not their thing, right? They're into supervision and making sure people are behaving. So I think that providing funding to local jurisdictions to provide reentry services is important. And for that reason, I like SB 678, but I don't know.
As a Superior Court judge, I'm curious, when you impose probation as I guess a sentence, were the terms of probation something that you thought carefully about, or were they kind of that you just deferred to the probation department and kind of a cookie cutter approach about the terms that somebody might need to comply with in order to complete their probation?
So I'll give you a third option, which is the judge's ability to create their own terms and conditions of probation that fit the case. And so, yes, there were standard terms and conditions of probation that were applied to just about every case. They had to do with reporting, narcotics use, testing, all of that stuff. The suspension of Fourth Amendment rights so that probation could, whether you like it or not, stop you and search you without probable cause. But then there were also things that judges could insert as terms and conditions of probation, like educational requirements. I frequently ordered probationers, for example, in lieu of time in the county jail, to meet with a counselor at my former community college and take an admissions exam and consider that as an alternative to their current lifestyle. Yes, so the answer is, it's a tool that judges can modify if they're interested in modifying it to create terms that are specific to a defendant that they're dealing with.
Do we have any sense that they are truly modified, or are they pretty much people follow the standard terms?
I think the general practice is to impose the standard terms.
And do we know if the standard terms have been revisited or are worth looking at? Or?
No, I wouldn't know. I don't know. I've been off the bench now for 4 years. I don't know. I suspect that, and I don't speak for my former colleagues, but I suspect that they rely heavily on probation to let them know what the appropriate terms and conditions of probation should be in each case, because they're the ones that have sat down and met with the person that's going to be sentenced. But the thing about the court's ability to create its own terms and conditions of probation. The court can identify its own priorities for a particular person that they're about to put on probation, and there's almost, at the time that you're granting probation, there's almost no limits to the things that you can impose without getting too weird, because of course the public defender will say, hey judge, come on, my guy's going to get violated if you impose that term and condition. But I really think that probation can be used. It's not used enough, but can be used as a recidivism reduction tool when focused on education and job readiness, for example. You can really use probation terms to sort of redirect someone's energies and time, particularly when you make it clear that they're not going to jail today at all as a term and condition of their probation, if they agree to do such and such. Of course, most probation sentences, or many probation sentences, come with a little bit of county jail time up front, but they don't have to. And in a county like Los Angeles, where 180 days in the county jail as a term and condition of probation means 10 days, there's almost no point in imposing county jail as a term and condition of probation if you can leverage some other behavior from the sentencing person, the person that you're sentencing, to try to improve their performance in the community and reduce their recidivist behavior.
Justice Moreno, do you have any experience here?
I do have experience, but it's a long time ago. But you know, I left the Superior Court in 1998 when I went to the federal bench, where probation was much more well-resourced and so forth. But I basically agree with Peter. I mean, in misdemeanors, the probations are all what we call summary probation. I mean, there's certain statutory requirements like in DUIs and so forth. The Fourth Amendment waiver, the do not annoy, harass, or contact the complaining witness, no firearm possession, et cetera, et cetera. They're all pretty standard conditions. It's only in certain cases where, with the input of the public defender or the DA, you want something specially tailored to a particular case, like education or compliance with a certain program, that if the defense counsel has already looked into something for a particular defendant and it sounds good, and you impose that as a condition. So most of I'd say the thousands of probations that I imposed were in misdemeanor situations. Ironically, in some instances, as Peter said, the defendant doesn't want probation. He just wants the 1 year in county jail or low term or midterm state prison, and there's no probation. There's parole that comes later. So I've seen that happen as well. But the conditions, I mean, answer the question, are just pretty much basic and tailored to a particular case.
Putting aside the politics for a second, I was wondering how people responded to the idea that probation shouldn't be limited to specific crimes and perhaps opened up to more serious offenses.
What do you mean?
Well, right now, probation is only available for certain crimes, right? Certain crimes are not, you're not allowed to get on probation at all. Is that correct?
I mean, there are a few that I can think of, and there are probably some sexual assault cases that fall in that category. I do recall the second conviction for possession for sale of certain narcotics was a minimum 3 years, no probation. So there's certain crimes that are probation ineligible.
But you're saying that they're not a lot. Perhaps this isn't as big a problem as I had concerned.
Yeah,
Tom,
I don't think so.
Tom, do you have any sense of the exclusions?
I believe it's all serious or violent felonies. So I think it's those circumstances that Senator Skinner is talking about.
Yeah.
So serious and violent felonies are not probation eligible.
Correct. And there's some other one.
That's not altogether. That's not altogether true.
Yeah.
For example, I'm sorry.
Go ahead, Peter, and then Carlos.
Go ahead, Peter.
No. Justice Moreno, I think, should be allowed to speak first because he is retired from the Supreme Court.
No, I'm just saying burglary.
Right.
maybe it's residential burglary, there's no probation, but second degree burglary, felony, you can put people on probation.
Well, actually, one of the conflicts I had with the DA's office in Los Angeles County was around my college program, where I was in fact sending first-degree res burg kids who were usually 18 years old with no prior criminal history. I was sending them to college and not putting them in the county jail. And so the larger problem, I think, is the presumptive state prison cases, right? Where judges are warned, we expect you to put this person in state prison, and if you don't, you better create a good record for why you're not. Right. The presumptive state prison cases exceed the mandatory state prison cases. I'm sorry for the doorbell, but what are you going to do?
No, that's quite right. Did I see a question from Senator Skinner? Okay. Well, this is a very empirical question about we can find out what crimes are explicitly excluded and where there are presumptions. I think that we would agree that there are, within California's penal code, crimes that are defined as violent, purse snatching, right? That's a violent crime, might be a good candidate for some of these programs that we're discussing, and that they take up a large percentage. Robbery and burglary are serious and violent crimes and take up a large percentage of people incarcerated, including people in state prison. So that's just a pure research question, Tom, that we should figure out where that lands, and then we can discuss it a further conversation. Before I summarize where we stand, Tom, is there anything from the probation conversation that I've missed that we should touch on?
I think the other thing perhaps worth discussing is Chief Keene talked about targeting services while on probation, and perhaps whether that needs to be part of the penal code somewhere to make sure it's sort of done everywhere and not just in jurisdictions that are being more proactive.
I don't understand what you're saying. What do you mean targeting services?
Well, I think if you sort of what Judge Espinoza was talking about, where the judge may impose a condition of, you need to take a look at, community college or an education program, whether probation departments are doing that even without a judge's direction to do that based on their assessment of the person's risks and needs.
Okay, well, we can certainly look. Does anybody have any thoughts on that last piece? Yeah, Assemblymember Kamlager.
Not on that, but Dean Richardson had asked if maybe we could get the data on the kinds of violations, so if they're technical in nature or not. I'm also wondering if there's a way to find out when the violations either occur or are recorded, because I've heard in many instances, you're on probation and then towards the end, all of a sudden you rack up all of these violations. And I don't know, so during the time with which someone is serving, when do the violations occur? And I suspect part of it is just, workload overload for probation officers is also an issue. And I think that's also maybe a lens through which we can look through some of these recommendations, is we also want to sort of alleviate that and not have all of these arbitrary, potentially violations get racked up, prolonging folks' time on probation.
I think that probation is really complicated and probably deserves, a lot more thought. There's things that we haven't even touched on are, the due process that basically doesn't exist in due process in probation violation revocation hearings. The idea that you might be caught for a new crime, forget about a technical violation, and the different incentives that people have to just get violated, basically giving up your due process rights. On the other hand, you don't pick up a new conviction, and maybe you just want the probation violation, but there is sort of a collaborative aspect of that in this sort of way. So we should think more about that. I understand that there are proposed amendments to 678 in the trailer, in some trailer language, and obviously the governor's budget, so we should keep an eye on that. So let me just summarize where we are on probation. So we want to keep an eye on what's going on with the governor's proposals, particularly the 2-year limit, the pathway to get off, any proposed amendments to 678. and try to develop, see if there's data, this is from Dean Richardson, on monitoring the criminogenic aspects of probation and surveillance, including, and those are also technical violations. I'm interested in looking at the standard terms of probation, which ones work, which ones don't. Do different states, different counties have different policies? The Fourth Amendment, you know, we don't need to require a waiver of the Fourth Amendment. Maybe that's not helpful. Maybe there's some intermediate step that we can take. That seems to be a particularly intrusive one. I'm particularly interested in it, and I think it might be some controversy because about technology's role in supervision that might be able to helpful. And I think actually in this COVID area might actually have be an uptick in, including ankle monitoring. There's scram monitors for DUI folks about keeping people sober. I mean, even urinalysis is a technological approach to probation that I think that there might be some advantages here. All of these, of course, are impositions on people and restrictions and punishments to some degree, but to the extent that we're trying to keep people from being behind bars, I think that it can be helpful and perhaps tie into some of the other ideas that we're talking about successful completion of probation, whether it's expungement, outright dismissal, or the diversion, or that we've all talked about. These might be possibilities. Okay, so those are the areas of interest in probation that we will continue to research. Senator Skinner.
Just as FYI, my public safety committee staff do have a comprehensive list of all the probation ineligible offenses, so they can provide that.
That's great. So we should find out what's eligible, what's not, what's presumptive, and perhaps that list should be looked at and see if it makes sense one way or another. So I think that, again, that's another theme that's been going on about, which crimes should be eligible. This eligibility, suitability issue that's come up a couple times. All right, we've come up on another hour of conversation, but we don't have too much more of our meeting to get through. So without objection, I'd like to try to power through the rest of our meeting. Does anybody need a break, or can we power through? Okay, we're gonna power through. So I think we've exhausted the list and given Tom and Barbara and Brian quite a list of stuff to research. They will come back to us with further information and proposals in each of those areas at our next meeting. Right now, we're going to move to sort of Act 2 of our 3-act play today, which is old business. I don't really think that we have any old business or much old business from our previous meeting in the Capitol. Brian, am I missing anything that we should touch on in the old business category?
No, I don't think so.
The only thing that I will mention here is, as I alluded to, is that I think that there seems to be at least real response to Craig Haney's talk or seminar, or however you want to discuss it, as being very helpful as far as providing an overview. And first of all, I want to make sure that all of his materials are available to you from that presentation. But also, I'd like to put together something similar as we move into the realm of sentencing. I don't think we'll need to make this a formal committee hearing, but have some sort of seminar in the next couple of weeks before we dig deep into sentencing, about sentencing policy and data generally along the lines of what Professor Haney presented, just a somewhat deeper dive into what he said. So that's all I have from the old business. Anybody have anything else to say from the prior hearing that they'd like to make sure that we address? Okay, so let's move into the third act, which is administrative issues, and I'm going to turn this over to Brian to make sure that we close out, making sure that we dot all our I's and cross our T's.
Yeah, good, thank you. There's a couple of memos under tab 5 in the binder. They're pretty pro forma, shouldn't take long to get through them. The first is just approval of the minutes from the last meeting. Open Meeting Act requires that we memorialize the actions taken at a meeting. There wasn't much at the last meeting that was actually decided, but I think it's still a good practice to establish a pattern for this and do it consistently. I think the minutes for this week's meeting are going to be much more significant. And it's my intention that the minutes are not going to be any kind of a transcript or memorialization of testimony. They'll be limited to the decisions that the committee has made. And, you know, I intend to interpret that a little bit loosely. There'll be times when we take formal action, like I'm going to ask you to do to approve these minutes. But most of what we've done today is more informal, and the minutes will just sort of memorialize what came out of the discussion. So on a particular topic, which items staff's going to research and bring back, we'll have a record of that. You know, and that's useful for historical purposes. It's also useful if after that's prepared and released, you think we missed something, you can let us know and we can supplement it. And so part of the process we're going to be using is that when you see the minutes, if you think that there's an omission and you tell us, then we'll do a supplemental memo that raises that as a possibility. So you're either going to approve the minutes as submitted or as proposed with revisions. In this case, there are no proposed revisions, so it's just a matter of voting to approve the minutes. The Open Meeting Act on teleconference actually requires a voice roll call vote. So somebody needs to make a motion to approve the minutes without change, and then you need to vote on it.
So I move to,
Oh,
Carlos, do the honors, please.
I'll move to approve the minutes from the last meeting.
Second. Aye.
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 And the minutes are approved. Thank you. Anything else, Brian?
Not on that one. The second memo has to do with meeting schedule. And there were actually a couple of points there. One was approving the provisional meeting schedule that we had worked up after checking everybody's availability. And then the second point was approving some discretion in the chair to propose modifications to and sort of work out informal accommodations on the fly without getting a vote of the full membership. And I think it's maybe worth pointing out that while we've reserved these 2-day blocks, that was done pre-COVID. And it was built in part around the assumption that we wanted, that people were going to have significant travel burdens, and we wanted to minimize those. And that's why we were meeting every other month, you know, making the first day an afternoon session, the second day a morning session to make it easier for morning departures, evening returns. That's all sort of open again. And part of this that Michael has talked about before is the notion of making shorter sessions more frequently. I still think there's value in keeping a 2-day back-to-back session so that we can do what we did here this week, which is hear information the first day and have discussions the second day while it's still fresh. But you know, everything is negotiable at this point. But the proposal in the memo would be to keep the July, September, and November dates subject to chair discretion to make modifications. And if anybody wants to propose anything different, we can talk about that too.
So I'll add that I hope that we can just hold those dates for the time being, and that in the interim, we'll work to see if we should interject shorter meetings to get our work done. Does anybody have any thoughts about that?
It's fine.
Fine.
Do we need to vote on that, Brian?
No, I think I can work off consensus on that.
Yeah.
All right. So we're coming to a close here. Before we do, I just wanted to say thank you all. This has been a long couple of days. We're just getting this committee off the ground, so there's been a lot of extra work, I think, on all of our parts, but particularly the staff, Barbara, Tom, and Brian. We're doing a lot of work behind scenes to gather some of the data that we've been talking about, speaking with a lot of stakeholders. We will report back to you formally at our next meeting, but informally, please, please, please do not hesitate to reach out to me in compliance with the Open Meeting Act. We can't all gather, but you can certainly call me and we can have conversations or speak to committee staff. We'll be working hard on all of the things that we talked about today and then preparing for our next session, which will be, we're going to move into the area of sentencing. So unless anybody else has anything else left to add, I'm going to bring the committee to a close. Going once, going twice. All right, thank you all very much. Please stay safe and sane, and I look forward to seeing you soon. The committee is now
Everyone, thank
out
you.
of session. Bye.
Thank you.
Bye.
Bye.
We didn't get bombed.
Yeah. Oh, now you shouldn't have said that.
Good work.
Bye.
Good work.